I will not allow your number 82 to stand. So the media, we don't want anybody to go and report that the majority members were 82. We are 122.
Honourable members, we have spent so much time on the business statement. To everything, there must be an end. So I'm pleading with you. Let's conclude issues on the business statement.
Okay.
And then we can make progress.
Thank you, Mr. Speaker. Mr. Speaker, I won't say much except that I have a pending application, but I want to draw your attention also to our standing order 24 A, B, C, and D. And Mr. Speaker, standing order 24 A says that the Speaker shall uphold the honor, dignity, sanctity of the House. B, promote consensus on matters under consideration in the House. And then C, be impartial, fair, and firm in matters. And Mr. Speaker, I want to invite you to abide by this. You have steered the affairs. You have steered the affairs of the House so far very well. And I invite you that I have raised issue and the 1992 Constitution and Article 104 that matters to be determined in this House must be at least half of our members, which is 138. Mr. Speaker, I want to end and submit humbly that you know what to do as we indicated. The number I put previously when I made the application was 77. I still stand by it. If the clerk or you direct it otherwise, and there's a different number, I will respect your decision.
Honourable members,
thank you, Mr. Speaker.
Sometimes we know the procedure, but deliberately we want to put out the wrong impression. We have two types of a quorum. We have a quorum for commencement and a quorum for decision. Now, any time the attention of the Speaker is drawn to the absence of a quorum, Speaker takes advice from the clerk. If we do not have the quorum, we ring the bell for 10 minutes and then the other consequential procedures follow. So when you make the application, in fairness, I told you your application is premature. I also indicated to you that by your submission in this House today, you have been in this House for 5 years, which we agreed to, and for all those 5 years you've been in leadership. Advise the Speaker on a single instance where a business statement is adopted by a vote. Honourable members, when you know the truth, let's go by it. When the truth is known, let's just go by it. Let us not set a bad precedent. To quote the minority leader, whether it is 20 years or 30 years, the table may turn. I always take that aspect of his statement very seriously. So today, don't consider where you are sitting today and say business statement should be adopted by way of a vote. Honourable members, the truth is only one. There are seniors in this House who attest to the fact, a bare fact, that we don't adopt a business statement by way of a vote. So, honourable members, let's help issues. Where there is no problem, let us not create one. So the ruling is that business statements are not adopted by way of vote. On this note, the business statement as presented is hereby adopted. Members, before we proceed, let me indicate that on the issue raised by minority leader, he is calling on me not to make a ruling, and I intend not to make ruling. However, Mr. Speaker, or the Speaker, would be here to make comment on the issue. But I would want to state clearly, by way of advice to all of us, that when a procedure is set down for a right to be exercised, it is that procedure that will have to be followed in exercising the rights. Honourable members, when motions are filed, the motion is supposed to be admitted. It must pass the admissibility test. After the motion is admitted, it is programmed on the order paper. Until and unless that motion is programmed on the order paper, it cannot be debated. So, honourable members, we can't pass through the back door to do what is yet to be admitted. This is not a ruling, but is by way of advice to all of us, that a procedure is there to guide all of us. On that note, I will defer any further comment to the Speaker. Majority Leader, let me announce the presence of students from American Cooperative School. They are led by Achampong Edward, headmaster, and they are from Efiduasi, Asokore. They numbered 117. Our members, on your behalf, I welcome them. May you have a fruitful stay in Parliament of Republic of Ghana. Yes, Majority Leader. Yes, Majority Leader.
Yeah, Mr. Speaker, I crave your indulgence so that we can vary the order of business and then do some small public business. We have spent 3 hours already, 3 hours that should have been meant for private business. We have spent it debating the statement. So let's do some small private business. I'm sorry, public business. So, Mr. Speaker, permit me to invite you to vary the order of business so that the Minister for Education can lay item 10A. Item 10A.
Minority Leader.
Mr. Speaker, we don't have any difficulty. It can be laid.
See, the people are going again.
Mr. Speaker, issues concerning the Education Minister normally, and now there are people are now leaving the chamber after being whipped to come and vote on business statement. They are disappointed, so they are leaving the chamber. But the Education Minister can lay the paper.
Honourable members, at commencement of public business, item numbered 9, presentation of papers. Or is rather item number 10A, presentation and first reading of bills.
An act to establish the Kwame Nkrumah University of Science and Technology, Kumasi, and to provide for related matters.
All members, the bill has been duly presented and it is referred to the Committee on Education. Yes, I am inclined to add the leadership of Constitutional Legal to help the Education Committee to consider this.
Mr. Speaker, again I seek your indulgence so that we can vary the order of business and take some 2 clauses, just 2 clauses of the Ghana Scholarships Authority Bill Just two clauses, Mr. Speaker. Mr. Speaker, just two clauses. Mr. Speaker, the agreement at conclave was that the Minister for Energy is unavoidably absent, and so we may not take his questions. That was the agreement at conclave. So, Speaker is a witness to that agreement. That was the agreement at conclave. So, in the absence of the Minister for Energy and Green Transition, I'm urging that we take the consideration stage of the Ghana Scholarships Authority bill.
Yes.
Mr. Speaker, I think we can go ahead with that, considering the fact that the majority leader have changed his tone from the time he was presenting the business, so we can go ahead.
Thank you very much, honourable members. Ghana Scholarships Authority Bill 2025 at consideration stage. He has instructed. Honourable members, going by the order paper, we have clause 3. So I will call on the chairman of the committee to move the proposed amendment.
Thank you, Mr. Speaker. Mr. Speaker, amendment proposed. Paragraph I, delete and insert the following.
Yes.
Mr. Speaker, with respect, we're just told that we should comply with our rules. Where is the chair of the committee? Mr. Speaker, we need to know where the chair of the committee is.
Yes, Majority Leader. Majority Leader, they are asking of the absence of yes.
Oh no, but you can respond. Mr. Speaker, we note that the chairman of the Committee on Education is on official duties outside of the jurisdiction, and therefore, by our rules, a member of the committee may be permitted to lead the discussions on behalf of the committee. Mr. Speaker, we plead that you permit a member, the Honorable Edem Agbana, member for Ketu North, is a member of the committee. He is able and capable of leading the, and we did that yesterday, Mr. Speaker.
Yes, honourable members, as indicated, the Speaker is here to take the chair.
Okay, thank you, Mr. Speaker. I think we won't have any difficulty with Honourable
members. I also indicated that he has his comment on the issue raised by the minority leader. So, honourable members will have to defer the consideration of the Ghana Scholarships Authority Bill 2025.
give me this one.
Honorable members, I patiently observed and listened to you, spent considerable time debating a report of the Business Committee. I had so many things to do, but I was compelled to leave that and to come to clarify some issues, particularly what led to the long discussion was I thought it was not necessary at all. We will not suspend the consideration of the bill. After my submissions, we'll go on with the consideration of the bill. But let me see. Honorable members, yesterday, I returned a proposed motion paper submitted by the Minority Leader, Honorable Alexander Afenyo-Markin, to the clerk in accordance with Order 1023, which according to the order is to be submitted to me as stated in Order 1024 as being inadmissible. As required by Order 1024 of the Standing Orders, I provided reasons on the face of the proposed motion paper for my refusal to admit the motion. I've this afternoon been compelled by what has gone on in the course of your attempt to adopt the report of the Business Committee, and I'm to provide my reasons to plenary as part of my efforts to ensure full disclosure. This, as you all know, is an administrative function. It's not something that should be done on the floor of the House. But the way the deliberations has gone on, it has left not only members, but our constituents a bit unclear about how we conduct things in the House. So this is an attempt to clarify the issue and to bring finality to the matter raised by the Minority Leader. Honourable members, the Clerk to Parliament received the proposed motion on the 28th of October 2025. As I said, it's a proposed motion. And so it's couched in the form of a motion by the Minority Leader, as required by the Standing Orders. It was forwarded to my office the same day. That's the 28th of October 2025. My office at the Secretariat received it, and it was later transmitted to me. It was now my duty to administratively consider the admissibility or otherwise of the motion. In considering the admissibility of the motion, I was guided by the provisions of the 1992 Constitution, the standing orders of the House, and precedents of parliamentary practice. Honourable members, a motion as defined in Order 6 of the standing orders of this House is a proposal made by a member of Parliament or a committee to do something or order something to be done or express an opinion concerning some matter. Orders 102 and 103 vest discretionary powers in the Speaker to determine whether a motion is admissible or not. In exercising this power, the Speaker must be guided by provisions as stated in Order 103 of the Standing Orders to either direct that the motion be printed or the motion is to be returned as inadmissible. Honourable members, I have considered deeply the proposed motion. I considered the text and I concluded that there was no basis for me to exercise the discretion to admit the motion. I have a copy of the proposed motion here. The motion, in summary, suggests that Parliament, as an arm of state, should stay its hand until another cognate arm of state takes action on a matter pending before it, even when there is no definite time for that arm of state to take the action. I find this suggestion constitutionally and procedurally unsustainable. Article 144, Clause 1 of the 1992 Constitution gives Parliament a clear and continuing duty to consider a president nomination for Chief Justice. That duty is not conditional on events elsewhere. There is no constitutional or standing order basis for Parliament to hold the process simply because there are pending cases in court. Should I accept that argument, it will mean that any litigant could hold Parliament hostage, that is, file a case and freeze the work of Parliament and its committees. That would undermine the concept of separation of powers and paralyze the constitutional machinery for filling, for example, in this particular case, key offices of state. Honourable members, I'm very mindful of Article 2 of the 1992 Constitution, especially Clause 2 of Article 2, which vests the Supreme Court powers to make orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declarations it has made. This article clearly states that should there be any unconstitutionality regarding the removal of Her Ladyship Justice Tokunu, the court is vested with the power to so declare, and make all necessary orders needed to restore the status quo. To that end, I'm of the view that courts can continue to hear whatever matters are pending before them, but until there is an injunctive order, Parliament's authority remains intact. Judicial independence should not mean legislative paralysis. In any case, I have consistently questioned whether the Supreme Court could use its injunctive reliefs to stultify the work of another arm of state. Is that the purpose of that relief? Honorable members, procedurally, I'm also mindful of Order 103, Rule F, which suggests that a motion shall not be a subject matter of an action in which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of the parties in the action. I have considered the provisions on admissibility of motion, and I submit that the proposed motion is out of order. As I have already indicated, I am convinced that the Supreme Court is vested with adequate powers to reverse any action should they deem them unconstitutional. This matter I have discussed with the minority leader who was bent on the motion being admitted. It's not that I'm just saying them now. But he gave me notice that he will definitely air his views on the floor. And I think that is why, as the majority leader said, even though you were discussing football, he brought in Ampe. In summary, honorable members, the major points of this ruling is that the motion is inadmissible, and same has been returned to the sponsor, the minority leader, Honorable Alexander Afenyo-Markin, as stated clearly by our standing orders. I thank you all for your attention. Honorable members, minority leader, you want to have another bite?
Respectfully, Mr. Speaker, I would want, with your leave, to respond to a matter because of Hansard. Mr. Speaker, we have reputational issues here. There are matters that perhaps you may not be in the know. And for the sake of tomorrow, I believe that I must not be denied the opportunity to make this point known for Hansard, because points have been made by you, added to your ruling, and it has gone into Hansard. Mr. Speaker, with respect, as you rightly stated, we filed this motion on the set date. We were very vigilant enough. We followed it to the clerk's office and ensured that same had been transmitted. Mr. Speaker, days passed. The clerk communicated to me that my motion cannot be traced. Mr. Speaker, yesterday I followed up again because I know that he who comes to equity must do equity and must be vigilant. Equity has never favored the indolent. So I didn't want to sleep on my rights. I followed up again at conclave and I asked the clerk to Parliament, has my motion had any decision so that the caucus can know what step to take in accordance with our rules? He then told me, Mr. Speaker, that you've asked him to now procure a copy of the motion from me because what was submitted could not be found. Mr. Speaker, this is truth and it's indivisible. I then procured my copy because I kept a copy in my file. Then he later said he's sent for his copy because he also kept a copy. I didn't allow him alone to come. I walked with him all the way to your office to make sure that the copy had been duly submitted, which you duly received. Mr. Speaker, I did not receive any communication until 3, the time is here. And sometimes people would want to do things, and if you are not careful, you lose your reputation. Mr. Speaker, with respect, it is here. Mr. Speaker, the time is 16:32. 16:32. When that is 4:32, after we had raised the matter, it was now sent, your minutes was sent to me via WhatsApp. Mr. Speaker, I am a student of this house. I won't do anything to embarrass myself. If I'm not sure, I won't do it. And I will not seek to embarrass you or embarrass my caucus. I don't want Hansard to record me as having acted in bad faith. Mr. Speaker, we filed this notice long ago. There is vetting on Monday. Vetting on Monday. We don't sit on Monday. What other time would we have as a caucus to air our views? Even now, your response has not been officially been communicated to us. We don't have it. Mr. Speaker, I will speak the truth on this matter, and I wouldn't want any impression to be created that I did something wrong. We don't have it. It is now that you have, Mr. Speaker, with respect, read out in public your reasoning. We will pick it. What time again do we have to file another process to air our views? But Mr. Speaker, this is Parliament. We will respect it. Mr. Speaker, we even attach our written submission. That was how transparent we were. We didn't just send a lame application. We attach a written submission with all the authorities, including the latest authority in this house, where the majority leader argued that Nana Boachi's process at the Supreme Court, which process was seeking some declaratory reliefs, should stop this house. And Mr. Speaker, the first Deputy Speaker, ruled in his favor, upholding his application. You may recall, Mr. Speaker, that I came to you with an appeal, and you admitted my appeal, and a motion for review was filed. Mr. Speaker, the motion for review is still here. This is the motion for review. It is in today's motion paper, order paper, motion 15. The pursuant to order 127 of the standing orders.
Just a minute.
Oh, Mr. Speaker, if you want to come in.
Normally,
he can have his right to speak after me. Mr. Speaker, at this point of order, I don't have a problem. Mr. Speaker, I don't have a problem. I don't have a problem. He can speak.
Mr. Speaker.
Honorable Majority Leader.
Yeah,
just
Mr.
a
Speaker.
minute.
Mr. Speaker.
Just a minute. Minority Leader, I've given you all the space to speak because you raised an issue of it. There are some matters I raised which may affect your integrity. That's why I gave you the space. Now, you stated something which ignited the immediate reaction of the majority leader and stood on his feet. I signaled him that he should allow you to land. But it seems the issue he wants to raise is so critical, he was drawing my attention, no, let me do it. So I just wanted you to hold your breath for him to do so and let me rule. Please, Majority Leader.
Yeah, Mr. Speaker, he filed a motion. You took a decision on the motion. You transmitted the decision to him. Whether it is hard copy or electronically, he has admitted that he has received your communication. You followed through and came to this house and communicated the decision. When he said you should give him permission to say some things because it had to do with integrity and credibility, we indulge him. Even my chief whip urged me to object. I said no. He's raising administrative issues. So let us have that clarification. But he's now going beyond that and litigating your decision. He is litigating your decision. He is arguing points of law in relation to your decision. He knows what our rules say. If you want to challenge the decision of the Speaker, you know how to do so. So please, you know the right thing. You may not be happy with the outcome, but this is not the procedure. You've raised the administrative issues. I think you've exhausted those ones. You have no right immediately to start arguing against the substance of the ruling of the Speaker. That will not be allowed.
Yes, Minority Leader.
Speaker, with respect, the beauty of our engagement here is the opportunity unfettered, as the rules will permit, to air our views. So I respect what the Majority Leader said. However, I submit that he misunderstood the point I was making. Mr. Speaker, clearly I was on the point where I was drawing attention to the fact that at all material times, where dissatisfied, I had followed due process, including the very subject matter of your ruling. Mr. Speaker, he had objected on same ground that a matter was before court, and the first Deputy Speaker had ruled in his favor. When I was dissatisfied, I filed an appeal before you, which you admitted, and that appeal has been pending since 5th of March. It is listed in today's order paper as motion 15, and quote, that pursuant to order 127 of the standing orders, the Right Honorable Speaker reviews the ruling of the first Deputy Speaker on the 5th of March, sustaining the preliminary objection raised by the Majority Leader, Mr. Mahama Ayeraga, against moving the private member's motion listed as item 16 on page 6 of the order paper of Wednesday the 5th of March. Mr. Speaker, perhaps if the space had permitted for us to determine this review application, maybe the approach...
Honorable Minority Leader, you are now going far beyond bounds. You know the tools of filibustering.
Mr. Speaker, no.
And the tool of playing to the gallery. I think this is what you are now employing. And I want to stop you at that. I don't want to go beyond that. But clearly, I allowed this to happen because you took responsibility for the motion and you personally came to me. But on the face of the motion, the sponsors of the motion are Honorable Anyumedu Entry, MP for Asante Achim Central, Honorable John Darko, MP for Swami, Honorable Gloria Owusu, MP for Trobo, Honorable Damata Salam Amma Apienima. Again, the motion that came to me is a motion paper with no attachment of any submissions. Please, these are administrative matters, and I am not to bring them to the House. But because you brought the matter to the fore in plenary session, I'm compelled to do so. Let's end it here, because you can always trace and trail submissions of documents through the administrative processes. There is no document that is received by my office that is not noted in the records of the Secretariat, and copies of the document kept in the Secretariat. We have all. So there's no way that a motion paper will pass through my Secretariat, come to me in a minute, and then it cannot be traced. It's not done, because we have copies there, and even the minutes that are put on the paper are also captured in the records of my Secretariat. So if members are not aware, you can easily trace these records. Nobody can tell you that they can't trace the records. They are available. And by my training, I keep records. I know one day when I'm not here, some people may raise some issues. And all of you holding responsibilities, you might be prepared to answer. Whether in 10 years or 20 years, allegation can be made against you. You need to defend yourself. You need to have records. Don't just lead them and go, and when you are called upon, you are found wanting because you are naked. So I have all this. Let's move on to the motion that was referred to earlier on, for us to continue with the consideration of the bill. Please. Honourable members, we go to page 7, item 17 of the order paper. Ghana Scholarships Authority Bill 2025 at the consideration stage. Honourable members, on the order paper, I see that we have 17 Roman 1, which deals with clause 3. If that is where you've got into, then I'll call on the chairman of the committee to move the motion for amendment of that clause.
Thank you, Mr. Speaker. Mr. Speaker, clause 3, amendment proposed.
Oh, are you the chairman of the committee?
Mr. Speaker, my chairman is not available and permission has been sought for me. He asked.
Oh, permission has been sought for you, and it was granted by my, yes, First Deputy Speaker.
Yes, Right Honourable Speaker, all the clauses here were
deferred clauses. So we've done everything, but clause 3, 4, and 5 were deferred clauses. So we are not starting from clause 3, moving to clause 4, 5, 6 onwards. We've done everything, but these are only deferred clauses.
Exactly that. So I asked him to move
Yes, clause 3.
clause 3
That is okay.
as proposed.
Yes.
But because he stood up and I recognize that he's not the
Right,
chairman,
Honorable Speaker, whilst I was in the chair,
you granted him.
yes, there was an indication that the chairman is outside the country attending to official duties at UNESCO in particular. So both parties agreed that in the absence of the chairman, a member of the committee could move the amendments. Hence, Honorable Adam Agbana is moving the amendments as a member of the committee.
It's just that it's procedural because I said chairman of the committee. And so he stood up. But I didn't get this explanation. And so, my good son, you may do so once you have the leave of the speaker.
Thank you, Mr. Speaker. Mr. Speaker, clause 3, amendment proposed. Paragraph I, delete and insert the following. I, award foreign scholarship for a program including skills upgrading that is not wholly available in the country. I so move.
Honorable members, motion is moved for the consideration of the House. Yes, honorable member.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, I want to make a counter proposal to this particular amendment. Mr. Speaker, if you look at the original...
Honorable member, you want to plead to put a counter proposal, or you want to amend further the proposal?
I want to amend further, Mr. Speaker. Thank you for the guidance. Right,
Thank you.
Speaker. Yes, Mr. Speaker, and I'm making reference to the intent of the Act, trying to ensure that scholarship that is granted are supposed to be for programs that are not wholly available in Ghana. And so in the instance where this application or this amendment is seeking to award foreign scholarships for a program including skills upgrading, that is not wholly. I believe that the word not wholly is very, very subjective and difficult to determine. Because what constitutes not wholly available in Ghana? So I think that the not wholly should be deleted or taken out of it, so that we stick to skills, a new rendition to the effect that it should be a program including skills upgrading that is not available in Ghana. Thank you very much, Mr. Speaker.
Do I give to my deputy? I think that the minister should have the bite before you. Yes, Minister of Education.
Mr. Speaker, I'll urge the last speaker to be persuaded to abandon his amendment. Mr. Speaker, the Committee of Vice Chancellors drew my attention, led by the Vice Chancellor for the University of Ghana, that they have what they call split-side degrees, where part of the program is taken in the country and a part abroad. This is what informed this proposition. I thank you. You may be doing a course, you have to spend 1 or 2 years in Ghana and spend another 1 or 2 years abroad in order to be able to complete it. If we restrict it to only what is not available in Ghana, it may be difficult for that category of students. That's why the committee was persuaded to reword the rendition. I thank you, Mr. Speaker.
You're not persuaded? Yes.
No, Mr. Speaker. I think the rendition doesn't give that impression, because if you say not wholly available in Ghana, it means that the course is not available in Ghana. But when please allow me to make my point. But if you say that, but from his explanation, it is speaking to cross-country programs. That is different from a program that is, if we say a program is not available, it means that that program, you can't find it in this country. That is what I understand by not available in Ghana. And that is why I believe that scholarship that is being awarded to students, we need to take a decision whether it should be granted only for courses not available in Ghana. And if we intend to make courses that are partially available in Ghana, or the rendition that is there, it lacks clarity, and it will be difficult for anybody to understand and give this as a meaning to scholarship that is not available in Ghana. So I'm not convinced with that. Thank you, Mr. Speaker.
Yes, please. I'll come to you. Let me listen to you.
Most grateful, Mr. Speaker. Mr. Speaker, I want to join the Honorable Minister for Education in urging my brother to abandon the proposed amendment that he wants to do to this. Mr. Speaker, the original rendition was award foreign scholarships for only programs that are not available in the country. Mr. Speaker, over the years, we realize are only available here do not allow members to do an upgrade of it outside. That is the reason this new rendition now says programs including skills upgrading, that is not wholly available. It may be available, all right, but it does not end. And so I urge my good friend to abandon his further amendment to what already exists. I thank you, Mr. Speaker.
Yes, First Deputy Speaker.
Mr. Speaker, thank you for giving me the opportunity to persuade my honorable member. Right Honorable Speaker, the original rendition in I is award foreign scholarships for only programs that are not available in the country. And our attention has been drawn to the fact that currently there is a program called Split Side. And that program, part will be offered in the country and part will be offered outside the country. Therefore, if you limit the award of scholarship to only program not offered in the country, it means you'll be denied the category of people admitted for that split side program. So in view of that, it is necessary to amend for the rendition to cover those people who would study courses that are not wholly in the country. That was what informed this particular rendition. If you leave the old rendition, then it means the category of the people who will be involved in the split side program who will not have the opportunity to be given scholarship.
Yes, Honorable Member for Kwadaso.
Mr. Speaker, thanks for the opportunity once again. Mr. Speaker, I remember when we met at Peduase looking at this bill, this matter came up, and I remember I raised the point that if we go by the original rendition, we are going to deny others from enjoying the scholarship. I remember it was not agreed upon. I'm happy that it has now found favor before the committee. So I support the current rendition because I used to be the CEO for National Accreditation Board, now GTEC. And we know how the systems work at the tertiary level. There are some programs, Mr. Speaker, they might even be run in this country and elsewhere, but in terms of the infrastructure, in terms of facilities, they might be enhanced or at an advanced stage out there than here. So if you say that you are not going to allow them to benefit, then it's going to be discriminatory. So I also want to urge our colleague that this current rendition best supports the intention of the bill so that it doesn't exclude others who, per the program they are pursuing, from enjoying the scholarship. Thank you, Mr. Speaker.
Well, honorable members, between wholly available and fully pursued, which is preferable? That rendition has been given to me too. That is not fully pursued in the country. And then that is not wholly available in the country. Which one is preferable? Matter of policy. Minister.
Mr. Speaker, I was consulting with the first deputy, who is a modern draft person, to help see if I can get the word split side programs. Those are the words the Vice Chancellor of the University of Ghana, Professor Nanaba, shared with me. And she provided further elucidation to explain what that meant. Fully pursued, Mr. Speaker, will not do any harm, but maybe we could have said award foreign scholarships for a program, including split side programs and skills upgrading. That is not fully pursued. I'll go for that, but I'll bring in the word, the split side. And Mr. Speaker, just as you are guiding us. For instance, she studied medicine, yes, and she studied a particular enterprise of medicine.
Yes.
Today, she probably may need artificial application of medicine in dealing with the same enterprise of medicine. That artificial intelligence leg may not be available. So if we can do it, I'll be guided with your words, not fully pursued, but I'll still import the words split side programs. And then we define split side program in the interpretation as a technical word. Thank you.
Yes, please.
Thank you, Mr. Speaker. Guided by what you said, I believe that programs are mostly run. So I would have suggested the award foreign scholarship for a program including skills upgrading that is not fully run. That is not fully run in the country. So that would, I believe, rather than.
So you prefer run, not pursued. Drafting is a very difficult subject, and language matters. I've been a former Minister for Health. I'm aware even our country also benefit from that. Sometimes some countries in the study of medicine don't have the level of clinicals that we do here. So they will study the biological sciences and the rest and bring their students to Ghana to come and continue with the clinicals. And so you have those things happening, and particularly with modernization and the introduction of new technology. For example, robotics, AI, and the rest. So you have those split things. The idea is good, it's well accepted by all, is the appropriate wording that we are now trying to build consensus on. And so I got this, and I want to put a question